everything. So yeah, that's kind of a weird thing to see. But you can watch all the courses, all the classes from this year's course and the complete lecture series. You could see the July course from July. You could see the essay courses, and these ones have individual lectures. These are just me, especially the ones that are just backgrounds. That's just me talking into the camera, telling people things. But what I've just added as of this morning is this folder, 1-minute video reviews for every single subject. You can see the growth of my forehead. And I do tips and tricks every MBE subject, and then I do all the Florida subjects. Just to give people an idea. Ooh, business entities. Let's see what I got.
I think of all the subjects on the Florida bar, business entities give students the most trouble because they're lawyers, they're not business people.
Okay.
So I'm going to try to give you a few simple tricks to help you on Florida multiple choice questions. First, let's distinguish between common stock and preferred stock. Common stock has voting rights. We get to vote for the board of directors. We get to vote for fundamental changes such as stock splits, mergers, acquisitions, or changes to the corporate charter. But common stock has junior liquidation priority, which means in the event of a liquidation, preferred stockholders will get paid out first. Preferred stockholders have priority when it comes to dividends. Another thing to note about partnerships and corporations is the different types of entities. A C Corp is subject to double taxation and limited liability, whereas a general partnership is flow-through taxation and unlimited liability.
Solid. A+. I mean, a little bit of stuttering. Like I told the class, I did these back to back to back to back to back, pretty much one take on all of them except maybe 2 or 3. But I think they're good. They're right to the point. And try not to judge me by my appearance. Just try to listen to the words that I'm saying. Okay, so they are added in the folder right here, 1-minute reviews, and they're added to the drive. Hopefully that is helpful. The other thing I wanted to note is we've added the complete 100-question practice test. So it's a really good way to reinforce multiple choice material is to do the practice test. I will say the FBBE official test that we've had the explanations for is the #1 source to familiarize yourself with the types of questions you're going to see on the Florida multiple choice exam. Florida multiple choice is super difficult to prepare for because they have a whole universe of material they could test from, but then they only narrowly test a few of the subjects. So if it were me, I would focus less on Florida multiple choice down the stretch and more on memorizing the key points of Florida essays. And when it does come to Florida multiple choice, focusing on the dates and times. And if you go to our classroom, you could see one of our star tutors, Amy, has her study materials because she was also a former student, and she has some of these really great time to do sheet and other things. I think these are great sheets. Another thing that I really like is I had a student named Hannah, fresh off a bar passing experience and a wedding, and she contributed to the class, and this will go down in history as one of the greatest things ever contributed. And Hannah is super cool and a friend of mine. These dates and times. You go to civil procedure, civ pro dates and times. I mean, I don't know what I did with it. I had it earlier. I literally just posted it on my story, but there's maybe it's civ pro attack sheets. Aha, there it is. See, civ pro attack sheets. Good thing I did this for everyone because you might not have been able to find that. There's these civ pro attack sheets. Specifically these beautiful colored ones. They were created by Hannah, who recently got married. And I don't think she really thought to invite me to the wedding. I don't really like going to weddings anyway, but she is a friend of mine, and she made these amazing sheets, right? And they are super colorful, and they're great for times, like, everything that you could need to know for civil procedure. like motion for a new trial, 15 days. Failure to prosecute when there's been 10 months of no activity. Summary judgment, no genuine dispute of material fact. Let's see. Right, you can zoom in and see how attention to detail is just phenomenal. Kind of like these gift baskets right here, just phenomenal attention to detail. And I think this will really help people. I would study from these down the stretch, right? 120 days. So make sure everyone can access them. They were made by Hannah. We're super grateful for Hannah. Make sure that we can access Amy's study materials, especially her time to do shit stuff. And then I really like Joel's outlines. Joel, you know, crushed this test and he made really good outlines for every single subject. So, you know, a lot of things you could focus on down the stretch if you're feeling nervous. I'm trying to pinpoint what I think are the best materials to address your needs. And then another new piece we added was one of our students who I could say with absolute confidence is doing phenomenal. Completed all the classwork, all the assignments, and he's clearly got a big heart because he shared his complete outline with the class. And I mean, frankly, this outline is phenomenal, right? If you read this from start to bottom, you could probably pass the bar exam, even if you never studied before in your life. Like, it's just an absolute comprehensive, phenomenal outline. And it was made by someone who I have a lot of faith in. I mean, sure, I haven't reviewed every single tiny detail, but you know, I would trust it over some of these other big box companies that don't really review much either. This looks really phenomenal and super grateful. If anyone wants to try and, you know, one up this outline, be my guest, but this might be the greatest outline I've ever received. So there's that. All right, speaking of greatest things I've ever been received, I know everyone should know that I'm working on a book. I put the link in the chat. I'm gonna read from one chapter today, and then we're gonna do review of questionnaires. All right, let's get to it. The story is about Stick Boy, and when you see the cover, I actually have the letters that me and my grandpa used to send each other, and it's pretty cute. Okay, so yeah, don't ever text me in all caps. If you ever text me in all caps, that's like, it just sounds like you're screaming to me on the phone. Like, I just don't like that. My dad texted that to me one day. He wasn't even mad. He was just like texting something, and I had to let him know that we can't text in all caps. All right, talk about this. So few federal concepts that can almost always be mentioned on any common law essay. State action. The Constitution, let's just start right there, protects intrusion upon individual rights from government action. Actions by private entities are mostly excluded from the ambit of the Constitution, except in exceptional circumstances, such as the 13th Amendment, or if the state is sufficiently intertwined with private activity to justify constitutional protection. So we're looking to identify if there's state action. The Constitution doesn't apply to private activity. Standing. In order for a plaintiff to have standing, she must show causation, injury, and redressability. Third-party standing is rare, but is appropriate when a plaintiff cannot assert her rights on her own, and there's a close relationship between the plaintiff and the representative. Organizational standing occurs when any sues on behalf of its members. So state action and standing. Let's try and address them on every common law essay. Justiciability. In order for a case to be heard, the matter must be ripe and not moot. Ripeness means that the case is sufficiently developed, it's not too early, and mootness means that the issue has already been resolved, it is too late. A matter is not ripe if the act or ordinance has not been passed yet, for example, and a matter would be moot if the project undertaking that is contested was already completed, like the building of a bridge. An issue is not moot if it is repetitive and capable of evading review, such as allowing handicap access for bar takers. The bar is administered twice a year, or a pregnancy claim. People can reproduce human art every 9 months. Little inside jokes, right? Courts will also refuse to hear political questions, although this concept is mostly applicable to the Supreme Court and has never been tested in Florida essay so far. Common law and property are significantly more difficult than torture contracts because there are so many different ways that they can test the numerous subtopics, and there isn't as reliable of a blueprint. For common law specifically, you can almost always begin by addressing state action, standing, and justiciability. However, after that, there are many different paths, and your job is to be well equipped with constitutional arguments and apply the relevant ones to the fact pattern. In regards to federal law issues, I have ranked and defined the following concepts in order of likeliness to be tested on an essay. Number 1, Fifth Amendment due process. Let's always remember, Always remember that there are 5 important parts of the Fifth Amendment: due process, takings, right against self-incrimination, Miranda rights, and double jeopardy. The Fifth Amendment due process rights apply to infringements by the federal government, but has been incorporated to the states through the 14th Amendment. Procedural due process requires notice and hearing before the government can deprive an individual of a life, liberty, and property interest. Examples of recognized areas of due process interest in Florida include personal belongings, realty, chattel, money, public education, and welfare benefits. Whereas procedural due process refers to the rules the government must follow, including notice and hearing, substantive due process refers to the actual intrusive policy. Substantive due process is a deprivation of everyone's rights, while equal protection is when a specific group or class is targeted. Equal protection. The 14th Amendment guarantees equal protection and prevents any state from depriving any person equal protection of the laws. Specifically, Florida recognizes that no person shall be deprived of any right because of race, religion, national origin, or physical disability, the suspect classes, unless the government can survive a strict scrutiny analysis. In essence, the government must treat all people the same. Laws that target gender illegitimacy are subject to intermediate scrutiny, while all other laws, including those targeting wealth, age, or just incidentally impacting a suspect or quasi-suspect class, are subject to rational basis review. First Amendment freedom of speech. The freedom of speech is a fundamental right guaranteed by the First Amendment of the Constitution. Content-based restrictions, such as a law prohibiting the display of signs critical of a government policy, are presumed unconstitutional and are subject to strict scrutiny, and the government must show the regulation is necessary to achieve a compelling interest and is narrowly tailored. Content-neutral restrictions, such as zoning laws regulating the operation of strip clubs to a certain part of a city, are subject to time, place, and manner restrictions and a heightened form of intermediate scrutiny. Specifically, content-neutral based restrictions must be necessary to achieve an important government interest and leave alternative means of communication available. I would like to tell everyone about something. It's called writer's block. It's called when you're writing and you're grooving and then you stop writing for weeks. It happened at this exact moment. Like I wrote this until like Christmas and then I couldn't pick it up until like the middle of the night on Tuesday. You know what I mean? Like it was just hard for me to get to this discussion. I had to do a lot of research and I don't like doing research. I like writing from my own thoughts. So I hit writer's block here, but I pushed through it. Now there's no more writer's block. I've seen the finish line. You know, I'm a 5K runner, not too long. I don't like marathons or anything. Nice little 5K. This is a 5K book. I know the finish line and I can push through and get there. This was the part where I was like, oh my God, I gotta catch my breath. Like, am I really doing this? Do I even like running? Like, this is kind of boring. Okay, let's talk about this piece. Traditional public forum. To evaluate a governmental restriction on speech occurring on public property, courts must determine how the regulated area fits into the following categories of forums: traditional public forums, designated public forums, limited public forums, and non-public forums. So traditional public forum, like a sidewalk or park, are subject to time, place, and manner / content neutral restrictions, which are a heightened level of intermediate scrutiny. A designated public forum, university auditorium or municipal theater used for expressive activity by the public, subject to the same restrictions as traditional public forums, but only while holding itself out as a public forum during that designated time. Limited public forum, public school facilities open after school, interior of a city hall, for example. A forum open for expressive activities, but with restrictions to access based on subject matter and or speaker. It must be viewpoint neutral. Viewpoint neutral is a less stringent standard than content neutral because the content of discussion can be restricted to abortion, for example, but the viewpoint, pro or anti, cannot be restricted. Non-public forums, prisons, military bases, interior polling places, mailboxes of public school employees, or airports. The government has much more flexibility to limit speech so long as the restrictions are reasonable and viewpoint neutral. And then unprotected speech, see, now I got 3 writer's block, includes hate speech, words likely to incite imminent loss activity, obscenity, false or misleading commercial speech, and defamation. Obscenity appeals to the prurient interests of humanity and is devoid of any social or artistic value. And just kind of an inside joke, referring back to something I said earlier about reproducing human art every 9 months. That's where that comes from. All right. Now we can smooth sail to the end of this con law chapter. Well, almost the end. First Amendment, freedom of religion. Remember, there are 5 fundamental, you're always supposed to write a number if it's under 10. There are 5 fundamental rights guaranteed by the First Amendment, including the freedom of speech, the freedom of the press, the freedom of petition, the freedom of association, and the freedom of religion. The freedom of religion includes the freedom of association and free exercise. Religion is merely a sincerely held belief. Laws targeting religion are subject to strict scrutiny, while laws that incidentally affect a religion in a non-discriminatory manner are subject to rational basis. For example, courts upheld laws banning peyote. Is that how you spell that? Whoever tells me yes, you're about to incriminate yourself. But is that how you spell that word? For example, it looks like it rhymes with coyote. Courts upheld laws banning peyote, even though it was used in practice by a native religion since it was non-discriminatory, but struck down a law targeting religion's use of animal sacrifice as discriminatory. Remember, this was in like Arizona. This was right here in Miami. As of 2022, the historical lemon test, that should be italicized, but I'll do it later, has been abrogated as the courts permitted a football coach at a public school to lead prayer with his team after games. That's how I would write that, right? That's smooth. As of 2022, the historical lemon test has been abrogated as the courts permitted a football coach at a public school to lead prayer with his team after games. It doesn't really like address it or not. Let's see, is someone telling me? Yes, Grace, you Googled it. You're right. Grace just, I don't even know how you use peyote. I was gonna say she just took a hit of it, but I have no idea. Took a drop of it. That sounds more fundamental. Speaking of fundamental, the fundamental rights. The following rights are considered fundamental in Florida: the right to be free from laws targeting race, alienage, national origin, disability, the right to contraception, the right to marriage, the right to procreate, the right to educate your children, and the right for parents to have a role in the upbringing of their children. Mnemonics to help memorize the aforementioned rights are Rand and Camper. The right to abortion is no longer considered a fundamental right in Florida. Additional fundamental rights include the right to travel, the right to vote, the right to work and join a union, the right to privacy, the right to be a candidate, the right to be free from governmental takings, access to courts, procedural and substantive due process rights, the right to bear arms, the right against unreasonable searches and seizures, the right to counsel in certain circumstances, the right against self-incrimination, the right against double jeopardy, the right to speedy trial. You got to stay consistent with it, buddy. The right to confront witnesses and the right to trial by jury in certain circumstances. That's a nice little sentence right there, right? Let me read that one twice. Sounded nice. Additional fundamental rights include the right to travel, the right to vote, the right to work and join a union, the right to privacy, the right to be a candidate, the right to be free from governmental takings, access to courts, procedural and substantive due process rights, the right to bear arms, the right against unreasonable searches and seizures, the right to counsel in certain circumstances, the right against self-incrimination, the right against double jeopardy, the right to a speedy trial, the right to confront witnesses, and the right to trial by jury in certain circumstances. Access to courts, number 6. The Florida Constitution guarantees that the court shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. Be on the lookout for a law or ordinance that requires posting a bond, paying money, in order to go to court, or a law that has a clause restricting options for seeking relief. While access to courts is a fundamental right, subject to strict scrutiny, is important to note, my favorite saying, right, is important to note that under the Kluger Doctrine, which should be italicized, certain fundamental rights, including access to courts, can be restricted if there's an overarching public purpose. One example I can think of is potentially restricting access to courts during a pandemic for health concerns. That's fucking terrible, right? So I'm sorry, everyone. One potential example, I can think of is restricting access to courts during a pandemic for health concerns. The Kluger Doctrine should always be mentioned to support a counter argument against an argument for denial of access to courts, right? When you're writing these exams, you should have arguments and counter arguments just lined up, even if they're failing. Sunshine Law, the failing argument will be right to privacy. Access to courts, the most likely failing counter argument will be Kluger Doctrine. Arguments and counter arguments will save you. All right, scrutiny levels. When there is an equal protection issue targeting a specific group of people, there are 3 main judicial scrutiny levels to consider. Under strict scrutiny, the government has the burden to prove that the state action is necessary to achieve a compelling government interest and is narrowly tailored to that means. Strict scrutiny applies to deprivation of fundamental rights. Intermediate scrutiny requires the government to prove that the state action is substantially related to an important government interest and applies to sex-based classifications, illegitimate issues, and restraints on commercial speech. Heightened intermediate scrutiny applies to content-based time, place, and manner restrictions, as it requires the government to show that the state action is necessary to achieve an important government interest, and that leaves open alternative means of communication. Rational basis scrutiny places the burden on the plaintiff to show that the state action is not reasonably related to a legitimate government purpose. Rational basis applies to everything except for fundamental rights and to actions affecting suspect classes and quasi-suspect classes. Examples include regulations targeting age, wealth, teachers, or garbage workers, for example. Right? I was trying to I don't know, Shakespearean garbage workers, teachers, we're all treated the same. It is very difficult for a plaintiff to show that the government action is not legitimate and rational. The term rational basis with bite has been used when it can be shown that the government acted with animus. I feel like some of my students have some animus in them toward the challenging party and has usually been used by courts. I'm just kidding, not my students, but I like this word animus. Animus. Towards a challenging party and has usually been used by courts for cases involving discrimination based on sexual orientation. There you go. I actually define rational basis with bite. Okay, vagueness. A law is constitutionally vague if a reasonable person would not understand what type of behavior is being punished. Some courts have held that laws banning loitering, for instance, have been struck down because it's not clear what exactly is prohibited. Laws targeting speech are vague if a reasonable person cannot distinguish between permissible and impermissible speech because of the difficulty encountered in assigning meaning to the language. Overbreath. So vagueness and overbreath, you better write about it on Tuesday, right? Even if it's not if it's a torts essay, but I'm telling you, if it's common law essay, vagueness and overbreath should come in. A law is overbroad if it reaches beyond the scope of the subject matter it was originally intended to cover, causing it to cover activity that was not intended to cover. As applied to speech, a law is overbroad if it restricts more speech than intended. For instance, a law banning four-letter words at public schools would ban intended curse words, but would be overbroad for banning other words like duck and spit. Separation of powers. The separate branches of the government on all levels, including, this is an important one, right? This is a hard thing to write about, so I try to do my best to kind of, I don't know, make it digestible. And I actually talk about it again in my subsequent subchapter. But anyway, separation of powers. The separate branches of government on all levels, including local, state, and federal, are vested with certain powers that cannot be encroached upon or usurped. The executive branch executes the laws, the legislative branch proposes the laws, and the judicial branch serves as the final arbiter and determines the constitutionality of the laws. It is improper for any commingling, entanglement, or entwinement between the respective branches. On the federal level, the executive branch has veto power, the power to enact laws, the power to exclusively represent the country in foreign affairs, treatise power, the power to act as commander-in-chief, appointment and removal power, pardon power, and the power to make the State of the Union address. Congress has the power to propose laws, to tax and spend, to regulate commerce, to impeach, and to enact legislative apportionments, and to declare war. The judicial branch interprets the laws and subjects them to judicial scrutiny. Separation of powers. I want everyone to talk about that. All right, takings and eminent domain. Under the Fifth Amendment, private property cannot be taken for public use without just compensation. A possessory taking occurs when the government physically invades the property, and a regulatory taking occurs when government regulation renders a property either economically unviable or deprives the property owner of her investment-backed expectations. Condemnation occurs when the government offers just compensation for a taking, and reverse condemnation occurs when a private property owner seeks just compensation for the government for an alleged taking. Just making sure no one's entering the room. Okay. In the chat. All right, you guys are laughing about peyote. Hooray. I'm glad you're paying attention. Peyoting attention. All right, number 12. So let's take a peek back. What did Andrew say? Fifth Amendment due process is coming up, equal protection, First Amendment freedom of speech, First Amendment freedom of religion, fundamental rights, access to courts, scrutiny levels, vagueness, overbreath, separation of powers, takings, eminent domain. For what it's worth, I think this is valuable to have the subjects listed in order of, I think, likeliness to be tested because, you know, if you just have in a big outline, you could get lost, but I'm hoping that this is helpful. If not, it's good for my own health. All right, 10th Amendment state sovereignty. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to states respectively or to the people. This means that states have police power and can enact laws that are not preempted by federal law. 11th Amendment sovereign immunity. The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. See, the Constitution writes like we wrote on that Florida multiple choice, like super annoyingly, right? Because I took this right from the old Constitution itself. This means that individuals cannot sue the state except state officers in their official capacity or if the state consents. Florida has waived sovereign immunity for tort claims involving operational decisions, but not planning decisions. Running a parade is operational, whereas directing what route it goes down is a planning decision. Commerce Clause. Under the Commerce Clause, Congress can regulate the channels, instrumentalities, and economic activities that aggregate have a substantial effect on interstate commerce. So you can kind of see from here on out, I didn't get into too much detail because these things are rarely tested on essays. It's just kind of like, hey, you can mention and move on, but it's a Florida essay. It's not a federal. It could be. It could be. So we want to know about them for sure. Scratch that. Edit it from the recording. Vaso. All right. Dormant Commerce Clause. That's my graphic designer, Vaso. I'm not just talking to nobody. So Dormant Commerce Clause. States cannot enact legislation that discriminates against interstate commerce on its face or unduly burdens interstate commerce, right? Privileges and Immunities Clause. States cannot discriminate against out-of-staters. For instance, it would be unconstitutional to charge more for commercial fishing licenses for non-residents than for residents. Anti-commandeering Clause. Under the 10th Amendment, 10th Amendment over here, Congress cannot compel states to enact legislation like a no-gun law in school zones, but they can induce them through conditional funding, not paying for highways unless states agree to drinking age requirements. Nice. Ex post facto laws. An ex post facto law is one which renders an act punishable in a manner in which it was not punishable when it was committed. Contracts Clause. Under the Contracts Clause, state regulation must not substantially impair a private contractual relationship unless the state has a significant and legitimate purpose behind the regulation, such as the remedying of a broad and general social or economic problem, and the law must be reasonable and appropriate for its intended purpose. A heightened level of scrutiny is applied for situations where laws modify the government's own public contractual obligations. Bill of Attainder. A bill of attainder is an act of a legislator declaring a person or a group of people guilty of some crime and punishing them, often without a trial. One of my tutors, I named him Will of Attainder, but he wanted to be called XXX post facto. Whatever. Double jeopardy. A person cannot be tried for the same crime twice. Double jeopardy is the criminal equivalent of res judicata or claim preclusion. Jeopardy attaches in a jury trial after the jury has been impaneled and a bench trial after the first witness has been sworn in. All right, cool. I've also ranked the following Florida common law issues in likelihood of order to appear on an essay. There are some issues that overlap due to complicated interplay between federal and state law. Ultimately, you should be prepared to write about all issues using the framework of both the federal and Florida Constitution. So to go back, you're probably doing state action, standing, justiciability, due process, equal protection, freedom of speech, freedom of religion, fundamental rights, access to courts, scrutiny level, vagueness, overbreadth, separation of powers, takings. And then you're probably going into some of these issues. The Sunshine Law. Under the Florida Constitution, the Sunshine Law provides that public bodies are required to publicize all governmental activity and discourse. This law serves as a right of access for the people and ensures that legislation is conducted in the sun for all to see. There's an exception for unplanned meetings between two legislators, so long as one of them is not the governor. The law does not apply to private entities. A common unsuccessful defense to the Sunshine Law is the right to privacy, although the right of access in Florida will overcome this defense. It is still useful to mention this defense in an essay. The three basic requirements of the Sunshine Law are meetings of public boards or commissions must be open to the public, reasonable notice of such meetings must be given, and minutes of the meetings must be taken. Love it. All right, homestead exemption. I kind of went into detail on this and kind of was repetitive on this because I feel like I have a feeling it's going to be tested. So I wanted to make sure I said some things. There are two separate homestead protections in Florida: residence protection and tax deduction. The most frequently tested exemption is Article 10, Section 4, which protects against the forced sale of a person's primary residence from judgment creditors, except for property taxes and obligations contracted for the purchase, improvement, or repair of the house, such as construction liens, mechanics liens, mortgages, or homeowners association fees. This exception applies to a residence of up to half an acre inside a municipality and up to 160 contiguous acres outside a municipality. It also protects personal property up to $1,000. Furthermore, the homestead shall not be subject to devise if the owner is survived by a spouse or minor child, except the homestead may be devised to the owner's spouse if there be no child. There is no child, minor child. The owner of homestead real estate, joined by the spouse if married, may alienate the homestead by mortgage, sale, or gift, and if married, may by deed transfer the title to an estate by the entirety with the spouse. I feel like I could rewrite some of the statutory language and make it a little more clear. The homestead is also portable and applies to proceeds of the sale of a homestead, so long as the proceeds will be to purchase a new homestead. The homestead tax deduction includes a general $25,000 deduction that applies to all taxing authorities, and a second $25,000 deduction that excludes school board taxes and applies to properties with assessed values greater than $50,000. Therefore, most homeowners in Florida can take $50,000 deduction from the value of their homestead for tax purposes. Essentially, never basically, essentially, the homestead exemption protects a Floridian's primary residence from forced sale by judgment creditors, except Uncle Sam, and debts incurred as a result of financing or improving the home. It is limited to half an acre inside a municipality or 160 contiguous acres outside a municipality. Look for a street that divides a property and would end the homestead at the dividing line. A person can only claim one homestead, and so can their spouse and children. Homestead exemption is also a $50,000 tax deduction from the value of the home. Right, it's not a $50,000 deduction from your taxes. That'd be awesome. It's a $50,000 deduction from the appraised value of your home, which is still better than nothing. All right, enacting law in Florida. A proposed bill must have a clear title, a single subject, an enactment clause, be related to the health and welfare of the people of Florida, and not be vague or overbroad. In order to become a law, there must be bicameralism, approved in both the House of Representatives and the Senate, and be read 3 times, and there must be presentment to the governor for signature. There's no pocket veto in Florida, so an unsigned bill that has been passed in both houses still becomes law. Be careful, as these procedures are necessary for passing laws in Florida, but not all rules and regulations, such as municipal ordinances, need to comply with the strict formalities of enacting a law, although they can never be vague or overbroad and must always survive constitutional muster. Types of laws in Florida. General laws are laws that cover everyone in the state even-handedly and only require passage of the Florida legislature. A special law is one that applies to only a certain person or groups of persons or a certain geographic area, such as a city. Special laws require either notice before the passing of a referendum, after the passing, or the law will have no effect. General laws of local application are laws that are general laws that apply uniformly to an area, such as one that has a minimum or maximum population requirement. A good argument to make an essay is that a general law of local application is targeting a specific county and thus is attempting to circumvent voting requirements of a special law. That's some high-level arguing right there. All right, home rule power. In Florida, municipalities are vested with home rule powers such that they can regulate and exercise traditional municipal powers. These powers include the ability to pass municipal ordinances, which affect people in the municipality. Such ordinances may not conflict with the laws of the Florida legislature or impinge upon the Florida Constitution. Of course, the same applies for the U.S. Constitution and federal laws. The Supremacy Clause restricts overreaching ordinances. Types of counties in Florida. There are chartered counties and non-chartered counties in Florida. Chartered counties have home rule power, whereas non-chartered counties are subject to the general laws of the state. Special legislative sessions. The governor has the authority under the Florida Constitution to call a special legislative session. Special legislative sessions must be limited in scope, and the absence of the requisite vote of the members of the House and Senate, 2/3 vote, no new matters may be addressed during a special session, other than those for which the special session was called. While regular legislative sessions last for 60 consecutive days, special sessions can last up to 20 days and are convened at the request of the governor or joint proclamation by the Speaker of the House and the Senate President. Back to separation of powers. Just as there must be separation of powers at the federal level, there cannot be encroachment or entanglement at the state or local level. Certain powers are vested to the respective branches. Be especially on the lookout for law or ordinance that unconstitutionally grants sentencing power to a legislative or executive branch. Here we go. This is when I taught everyone in my boot camp the power of taking notes. I was telling the constitutional officers, and everyone's just shaking their head. And then I was like, none of you guys are gonna write this down? The point of the boot camp was for me to play a character. I was going for Coach Boone from Remember the Titans. But in reality, I'm not that tough. I just want to be tough because I know if I drag people through a training regiment, they will succeed. All right, constitutional officers in Florida include the governor, the lieutenant governor, the CFO, the Commissioner of Agriculture, state attorneys, public defenders, sheriffs, tax collectors, property appraisers, supervisors of elections, clerks of the circuit court, county commissioners, district school board members, and superintendents of schools. These officers have vested duties and must complete relevant ethics courses. I was reading the statute on this. That's how I boiled that down. I was like, doesn't look like fun. Kluger Doctrine. Here we go. The Florida Constitution. And just an aside, when you're writing these essays, it's always nice to say in Florida or per the Florida Constitution, right? Let the reader know that you're not just some Yankee Dan Marino hating guy who's just writing about laws. Let them know you're born and raised in no. Let them know that like this is a Florida essay and you're in Florida under Johnson v. Davis or under the Kluger Doctrine or Rosen v. Rosen. You know, if you can really get into the Florida specifics and you could do it simply by just saying in Florida, I think they like that. Okay, so the Florida Constitution provides that the right of access to courts will not be infringed upon and that justice will be administered without sale, delay, or denial. Sale, deny, or delay. When the legislator significantly burdens this right in a manner that amounts to abolishing a cause of action, a reasonable alternative must be provided unless the legislator can make the difficult showing that a public necessity exists and that no alternative can reasonably be established. That's the Kluger test. The difficult showing that a public necessity exists and there's no reasonable alternative. Amendments to the Florida Constitution. Proposed amendments to the Florida Constitution may be made by a joint resolution of the Florida legislature, a citizen's initiative, a proposal from the Constitution Revision Commission, or a proposal from the Taxation and Budget Reform Commission. A proposed amendment requires at least 60% approval from voters to pass. Defamation, and I talk about this in tort, so I didn't really talk about it so long, but remember, they like to test defamation because it does have constitutional implications. Defamation can be slander, spoken, or libel written. Defamation of a public figure requires actual malice. Defamation is not protected by the First Amendment. Ew, a hanging word. I hate that. Express right to privacy. The Florida Constitution was amended to provide that every natural person has the right to be let alone and free from governmental intrusion into his private life, except as otherwise provided herein. I mean, I know it was amended, but I'm just like, it's not beneficial for you to know that. The Florida Constitution states every natural person has the right to be let alone and free from governmental intrusion into his private life. See, the Florida statute says his private life. Let's make it more better. Into her private life, except as otherwise provided herein. This section shall not be construed to limit the public right of access to public records and means provided by law. Exactly. That is from the Constitution, that the right of privacy will not trump Sunshine Law. It can thus be stated that Florida's protection of privacy is even greater than that afforded by the U.S. Constitution. I gotta come back and edit this. I don't like using the word states twice. Let's just say so. It can thus be said that Florida's protection of privacy is even greater than that afforded by the U.S. Constitution. It's also important to note, always, and discuss in an essay, that the right to privacy will not overcome a Sunshine Law argument. I think I've really impinged that on y'all. All right, now we'll go into some other ones, but right here, these are the main ones for Florida, right? You should be very clear on the main ones. Sunshine Law, homestead exemption, enacting law in Florida, types of law in Florida, home rule power, types of counties in Florida, special legislative session, separation of powers. Those are some of the big ones, big ticket items, we'll call it. All right. Right to work. In Florida, the right to work is an enumerated right in the Florida Constitution. These rights are looked upon as fundamental rights. In Florida, one may not be granted or denied work based on their membership or non-membership to a union. Municipal bonds. I've seen this in an essay, so I teach it. I teach this so deeply on the Series 7 and Series 66 that it's like, I didn't believe it. That was actually tested on the Florida bar. When I saw it, I thought it was just like a nightmare I was having, but no, it's true. The crossover is real. All right, in Florida, there are two types of bonds that may be issued in order to finance government projects. GO bonds are bonds that repayment is guaranteed by the full faith and credit of the government. In order to pass a general obligation bond, there must be a referendum by the people on whether it may be issued. Things such as schools and bridges require no such vote. Revenue bonds are bonds that are paid back for the revenue that the project generates. Wait, I don't like this. I fucked that up. Sorry. Let me just say that. Municipalities may issue a bond without notice of maturity within 1 year. So let me reread that. In Florida, there are two types of bonds that may be issued in order to finance government projects. GO bonds are bonds that repayment is guaranteed by the full faith and credit of the government. In order to pass a GO bond, there must be a referendum by the people on whether it may be issued. Types of GO bonds include parks and schools. Revenue bonds are bonds that are paid back from the revenue that the project guarantees. Types of rev bonds include toll bridges and airports. Municipalities may issue a bond without a vote if it matures within 1 year. All right, fair enough. So GO bonds are backed by taxes, rev bonds are backed by the revenue of the actual project. GO bonds are subject to a vote or referendum.
Andrew,
Yeah,
can I make a question?
sure.
Who would be the person that asks for a municipal bond? Like who? Like
Okay.
a corporation or a person?
So a corporation, we got to think about who's the issuer, and this can tie in a little bit with business entities. So just a quick aside from my reading. So bonds are debt instruments. Stocks are equity instruments. Equity instrument, you own stake in the company. Bonds are promissory notes. You're going to pay them back plus interest, right? So who can issue a bond? It could be issued by a corporation. We call that commercial paper, right? That's commercial paper. Now, if a bond is issued by a municipality, we call that a municipal bond. Municipal bonds are tax-free investments. They're like one of the only investments on earth that's tax-free because it's from the government. You don't have to pay government for making money on a government issue. So municipal bonds are issued by municipalities. A company would issue commercial paper. A bank would issue a CD, a certificate of deposit. They're all essentially the same things. So a municipality will issue bonds, GO bonds or rev bonds. They'll issue GO bonds if they want to build a public school or a park. They just need money. And then they'll pay back the bondholders over time plus interest. With the taxes.
Oh, I'm sorry. I guess my question is who is the bondholder? I'm sorry. I made my question.
Me, you, Tommy, Johnny, people, and we buy them. The people give money to the municipality. The municipality gives us bonds that have a maturity date, and they'll pay us back over time, principal plus interest. So it's citizens. That's a great question. Don't be upset. It's citizens who are giving money to the municipality, so the municipality can either build a general obligation project, like they're doing it at Coral Gables High School right now, or a revenue project, like a toll bridge or an airport, something that brings in revenue. But how are they going to fund it? They're going to fund it through the issuance of bonds, which means the people will pay the municipality money and they get paid back over time, principal plus interest. Why is a GO bond subject to a vote? Because it's going to be paid back using taxes. So it's like, if you're going to pay back these people plus interest using my taxes, I should be able to vote on it. Excellent question. All right. Perfect. Okay, let's go to excessive bail. The purpose of a bail determination in criminal proceedings is to ensure the appearance of the criminal defendant at subsequent proceedings and to protect the community against unreasonable danger from the criminal defendant. Under the 8th Amendment of the U.S. Constitution and similarly adopted by the Florida Constitution, bail is excessive when it's set at a figure higher than an amount reasonably calculated to ensure the asserted government interest. Taxation considerations. Normally, all municipality property is exempt from ad valorem taxes, property taxes. However, when deciding if the municipality property is exempt from ad valorem taxes, you must look to the government purpose versus commercial purpose test. If the land is being used for private purpose, it is not exempt from ad valorem taxes. On the other hand, if the property is being used for government purpose, it will be exempted from paying these taxes. It is important to note that ad valorem taxes are levied by the counties and municipalities, not the state. That's an important note. Rights of convicted felons. This was I was actually learning just recently, man. I work in real speed. I was just learning this as I was writing it, like 2 a.m. in the morning. After I tutored y'all from 7 a.m. to 9:30 a.m., finally was able to continue working on my book after I got through my writer's block. And this is what I was working on last night. A person who has been convicted of a felony is not eligible to vote in Florida unless they've had their right to vote restored. Once their right to vote has been restored, they can register to vote. The Voting Restoration Amendment, known as Amendment 4, restores voting rights to felony offenders, except those convicted of murder or felony sexual offense, upon completion of all terms of sentence, including parole or probation. See, this is parole. I'm so sick of people writing parole evidence rule. That's parole evidence, right? And this is parole like that. Just a sec. Sorry. Okay. Furthermore, convicted felons who have not had their rights restored via clemency is the process you restore your rights, are prohibited from possessing firearms. So in Florida, convicted felons cannot possess firearms, serving on juries, holding public offices, holding certain professional licenses, and entering certain foreign nations, right? And something that very rarely, it's a rabbit hole that couldn't rarely be tested. You see, this is in order. So make sure you know sunshine law, homestead exemption, enacting law, types of law, home rule power, types of counties, special legislative sessions, separation of powers. Like that's the big 8. After this, it's like, hey, it could be tested, you know? I want to make you ready for anything they throw your way, right? All right. Pocket vetoes. Unlike the president, the governor cannot execute a pocket veto, which means that the governor fails to sign a bill that has been passed, that if the governor fails to sign a bill that's passed both chambers, it still becomes a law. During a legislative session, the governor must sign or veto legislation within 7 days of transmittal, or it becomes law without his or her signature. Post-session, if the legislative session adjourns, sine die, one of them's got to be close or combination of, with no appointment date for resumption, or for more than 30 days during the original 7-day deadline, then the governor must sign or veto legislation within 15 days of transmittal, or it becomes law without being signed. All right, advisory opinions, adversary opinions, tomato opinions. Unlike the U.S. Supreme Court, the Florida Supreme Court can issue these opinions. Under the Florida Constitution, the governor may request a written opinion from the Florida Supreme Court on certain legal issues, and the justices may render their written opinion not earlier than 10 days from the filing and docketing of the request, unless in their judgment the delay would cause public injury. Rules of judicial procedure. Normally, the legislature passes a bill by a majority of each house and then presents such a bill to the governor to either veto or sign. Under the Florida Constitution, however, the Florida Supreme Court has exclusive authority to create rules of procedure for the Florida courts. The legislator may reject such rules created by the Florida Supreme Court by a 2/3 vote, but the legislator may not amend or modify such rules. The Florida legislature has no power to create rules of court procedure, as this power is exclusively vested in the Florida Supreme Court according to the Florida Constitution. Prohibited subject matters. I got this right from a Florida essay. Special laws, as well as general laws of local application, cannot cover certain subject matter that the Florida Constitution expressly prohibits. Such prohibited subject matter includes taxation, elections, petite juries, conditions precedent to bring civil or criminal claims, venue rules, and rules of evidence. These subject matters are preempted by Florida state law. Original jurisdiction of the Supreme Court. All right, this is the last one for the Florida issues. The Florida Constitution gives the Florida Supreme Court the discretionary jurisdiction to hear appeals from the DCA for a variety of reasons, including if 2 DCA opinions conflict, if they are verified to the Florida Supreme Court as of great importance, or if they affirm the validity of a Florida statute or constitutional provision. The Florida Supreme Court has mandatory jurisdiction of appeals arising out of the DCA relating to bond validation proceedings, imposition of the death penalty, and the invalidation of a statute or constitutional provision. The Florida legislature may not extend or enlarge the discretionary jurisdiction of the Florida Supreme Court as constitutionally mandated. See, that's different than federal. Federal, they can, the appellate jurisdiction, they can amend or abrogate. In contrast, from the federal constitution, preempted myself. Congress has the power to enlarge or reduce the appellate jurisdiction of the U.S. Supreme Court, provided that it does so without excluding appellate jurisdiction of an entire subject of review. In federal court, they can't amend the original jurisdiction of the Supreme Court, but they can amend the appellate. All right, so remember, reel it all back in. I'm giving you everything. I'm trying to give the people what they want, because the people want everything, man. Ask anyone. So what do you need, though? You need the first 8 things to be well: state action, state justiciability, due process, equal protection, First Amendment, Fifth Amendment, fundamental rights, access to courts, scrutiny levels, vagueness, overbreadth, separation of powers, takings. I think those are key. Then you need to know sunshine, homestead, enacting a law, types of law in Florida, home rule power, types of counties in Florida, special legislative sessions, separation of powers, constitutional officers, Kluger doctrine. I think, the first 10 I would know very well. The other ones, if you're like, I don't know this, I'm freaking out, you're doing the wrong thing. Don't freak out. This is not here to help make you freak out. This is here to make it be like, I'm showing someone how to leave no stone unturned. But this is a minimum competency test. You could just write a decent essay and pass this test. I promise you that. But we're not going to write decent essays. We're going to write fantastic essays. All right. One last piece of things I want to read to you all, and then we'll go to the questionnaires. And I haven't done, as you'll see, I haven't done everything yet. So let's just do like the first three. All right. Fourth Amendment right against unreasonable searches and seizures. The Fourth Amendment of the U.S. Constitution, which is mirrored by the Florida Constitution, protects against unreasonable searches and seizures. Private individuals have a reasonable expectation of privacy in the persons it affects. A search occurs when a government or law enforcement agent conducts a search of a property, information, or conversations, and there must be probable cause supported by a warrant or circumstance excusing a warrant. Whether the police have a legal basis for stopping in or arresting a person depends on the totality of the circumstances surrounding each stop or arrest. Fifth Amendment Miranda rights. The Fifth Amendment right to counsel attaches when a person is placed in custody. Custody is generally defined as any situation where a reasonable suspect would not feel free to leave or where they're deprived of their freedom of action in any significant way. A person is not in custody during a routine traffic stop, but once they have been arrested, they are in custody. Right, Daniela and Barbara and Monique? Under Miranda, police must inform a person in custody of certain rights before conducting interrogation, which refers not only to express questioning, but also to any words or actions on the part of police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response from the suspect. Specifically, the Miranda warnings include the right to remain silent, that anything the suspect says can or will be used against them, that they have the right to an attorney, and that they have the right, if they can't afford an attorney, to be provided. If a suspect invokes their Miranda rights, police cannot continue interrogation for a reasonable time, up to 40 days. Any statements made voluntary unsolicited will be admissible. A violation of Miranda rights results in the inadmissibility of evidence, not the automatic dismissal of the charges. You can see, like, this is still a little bit of a rough draft for me, but it's key points. Okay, Sixth Amendment right to counsel and speedy trial. While the Fifth Amendment of the Constitution guarantees the right to counsel before adversarial proceedings have begun, the Sixth Amendment right to counsel attaches after charges have been filed. Unlike the Fifth Amendment, the Sixth Amendment right to counsel is offense specific. The Sixth Amendment also preserves the right to a speedy trial, the right to an impartial jury, the right to be tried in the jurisdiction where the alleged crime took place, vicinage, the right to be informed of the charges, the right to confront the individuals making the accusation, the right to compel defense witnesses to testify, and the right to assistance of counsel, which includes the right to the counsel of the defendant's choice, the right of appointed counsel, the right to conflict-free counsel, and the right to effective assistance of counsel, and the right to represent oneself without counsel. The exclusionary rule. The exclusionary rule provides that evidence from the government obtained in violation of an individual's constitutional rights is barred from admission at their trial. Under Rule 3.19, a defendant aggrieved by an unlawful search and seizure may move to suppress anything so obtained for as evidence because the property was illegally seized without a warrant. The warrant is insufficient on its face. The property seized is not the property described in the warrant. There was no probable cause for believing the existence of the grounds on which the warrant was issued, or the warrant was illegally executed. A motion to suppress is typically filed before the commencement of trial before a jury. Fruit of the poisonous tree doctrine. Under this rule, any evidence that is the direct result of illegal conduct on the part of an official is inadmissible in a criminal trial against the victim of the conduct. The Supreme Court has ruled that everything the officers discover as a result of an illegal arrest are fruit of the poisonous tree, not just a statement itself, but also the witness information gleaned from it and any other evidence subsequent that the witness led them to. Even a confession that comes after Miranda warnings may be admissible if it's the product of an illegal arrest and police misconduct, and the confession and illegal arrest are closely related. Exceptions to the fruit of the poisonous tree doctrine include the inevitable discovery doctrine. The evidence would have been discovered by other lawful means. The attenuation doctrine, there was no legitimate reason for the stop, but then the officer discovers an active warrant. And the intervening event doctrine, a voluntary admission is given after an impermissible search and is a separate basis for obtaining evidence. And then warrant requirements. In Florida, a search or arrest warrant must be issued by a neutral magistrate and contain a signature by an impartial judge, the name of the person being searched, a description of the items and premises searched, the person or items that are to be seized, any communication to be intercepted, and probable cause justifying the warrant. And then warrants, exceptions to the warrant requirement. There are exceptions to needing a warrant to conduct a search, and the mnemonic spaces can be used to remember them. The exceptions include search incident to arrest, plain view doctrine, automobile exception, consent, exigent circumstances, hot pursuit, and the stop and frisk doctrine. So then I kind of go into some of them: search and arrest, plain view doctrine, automobile exception, consent, exigent circumstances, stop and frisk, Terry stop, re-op, stand your ground. And now you can see I was just doing impermissible subjective lineups, and then I'm gonna do all the crimes, and then smooth sailing through real property, family law, and ethics. And by Monday morning, you'll have something to read while you're all super nervous. I hope that was valuable. You know, you can see I've been working super duper hard on that, but I also have been extremely busy tutoring. I think no less than 8 hours a day, 7 days a week for 4 months straight. But luckily for me, by this time next week, I'll be somewhere where no one can really find me. So until then, let's keep our foot on the gas pedal. What I'd like is some volunteers. Does anyone want to volunteer who feels pretty confident today? Any confident volunteers in Florida essays?
Yes, I
All
could.
right,
I
I
could give
got
it
you.
a shot.
Gabby, anyone else want to volunteer? You can put in the chat. I'll do the first ones and then I'll have some volunteers. It's not gonna be too hard, don't worry. All right, Hannah,
Okay.
yeah. Hannah definitely will do it. Let's see. Anyone else feeling confident? Omar, you're looking something over there.
Yeah, I'll volunteer. I got it.
You're looking comfortable.
Oh,
All
I
right.
am. I've stopped caring.
So
Let's
I'll
go.
I'll start and then I'll see who we can work with. Look, if I kind of interrupt you with a quicker answer, it's just because, you know, time crunch, we don't want to take too long. So try to do some, you know, these are supposed to be the top of your head, not the bottom of your feet. All right. I'll do the one that nobody wants to do. Commercial paper. These aren't essay subjects anymore, but they're still helpful. What's the definition? And so what I'm going to do right now in the final 30 minutes of class, hopefully 30 minutes, maybe 45 if we can, but it's gotta be lunchtime for the kid, right? So what I'm gonna do in the final part of class is go through these questionnaires blank. Smooth, easy, flawlessly, hopefully. If there's something I don't know, someone in the class help me out. To be fair, I'm not the one taking the exams. I'm just the one teaching the fundamental concepts. So some of the details are more on your shoulders than on mine, but I'll do my best. And then I'm gonna have some students go through it and show everyone what it's like. There's one way I know if you're ready to take this test or not. And so if I can go through these blank questionnaires and you can recite them from memory cold. If you can, you will absolutely pass this test. It is important to note that the Florida bar exam is extremely passable. I have had students who pass the Florida bar exam who, in my opinion, have no business ever going to law school or practicing law. They're just, you know, rich people whose parents paid their way through school and now they have to take this test and they studied and they passed it and then inevitably, you know, nothing comes of their legal career, right? To be honest, that's the majority of law students today. It's more of a title than an honor. You know, most people that I encounter just go to law school and become an attorney because they think it's cool. But the truth of the matter is that in a few years, when you're practicing, I'll ask you, hey, remember the bar exam? How it was so miserable, it was the worst thing ever. And you're gonna say to me, and I promise you this, the bar exam, Andrew, I have 3 clients on my ass right now, and I have to be in court at 4 o'clock, and I'm not paying the bill. You know what I'm saying? Life gets way bigger than this. If this is the biggest mountain in your life, then I'm telling you, you're not very well traveled, right? Or your travels will end at a low point because this is nothing. This is an easy test. I spend months telling everyone the Florida bar exam is the hardest test on earth, and then I peel back the curtains on the last day and tell you the truth. The Florida bar exam is so easy. The Florida bar exam is so easy. The Florida bar exam can be passed and has been passed by people who barely know the law, right? People like my dad. I can name a whole bunch of people. No offense to my dad, but he's not detail oriented like me or my grandfather's, right? He's someone who just kind of understood the basics and bullshit his way through it, right? Because you can bullshit your way through these essays. You can elaborate.